Jeffrey Clarke, former DOJ official during the Trump administration, also charged with crimes by Fani Willis, is now exposing more of the Nathan Wade cover-up. And he submitted a motion that we're going to read through that is joining the motion to disqualify her office, the motion to dismiss the case, and he's introducing some new elements to this. He actually did a little bit of a financial calculation, and he's telling us, remember when Fani and Nathan, they said that they split their bills evenly? They're like, a split check, please. Split check. We'll divide everything equally, and we'll be very, very accountable. Tell our bookkeepers about this as we're ripping off $1 million from Fulton. But he says all of that is leading to the inevitable conclusion they've got to go. And so you remember Jeffrey Clarke. He's been in a bunch of other litigation. They're trying to take away his law license. I mean, they're really trying to wreck this dude's life because in many ways they say he was a key player in the insurrection ordeal, right? And they want to go after the lawyers even to take him out of contention. But he submitted this filing in Fulton County, and let's dive right into it. State of Georgia versus Jeffrey Clarke, a co-defendant, one of the 19 in the RICO case brought by the biggest Fani in Fulton County, says that we are adopting the other motions. Okay, so new players are entering the game. Michael Roman submitted the first one. President Trump, he jumped into the game. Robert Cheeley, he's jumping in. Now we got Jeffrey Clarke, and he's jumping in. And here's what he tells us. He says, all right, Judge McAfee, hearing's coming up any minute now, and says Fani has three stark contrasts and conflicts that require a judicial intervention. Three big problems. Number one, she has a personal and financial interest of this prosecution because she's got a relationship with Wade, and it's lucrative, and it improperly awarded him contracts to enrich him and thereby in turn enrich her. Now, a government official cannot accept gifts from a contractor whose contract she approves, even if they don't have an intimate relationship, even if they're not indicting each other in their safe house. They had a safe house. Now, the second conflict arises from Fani's speech. She went to her church, the Big Bethel AME church, the pulpit, and she pointed the finger of racism at those who discovered and asserted her conflicts of interest. That's us, they say. Fani's motive in doing so is not merely stoking racial animus against the defense for its own invidious sake and to poison the jury pool corruptly to enhance her odds of getting a conviction and fame and fortune that will bring to her modern America, but also to exploit the racial resentments that exist to get out of her own scandalous predicament in flagrant violation of her professional responsibilities under the Georgia rules. Nicely done. Now, the third conflict, number three. The third conflict is that in her motion for a protective order in Mr. Wade's divorce, she exploited the power of her office and she threatened Mrs. Wade, Jocelyn, innocent, with criminal investigation and prosecution, again to solve her own scandalous predicament, again in flagrant violation of her duties under the law. And she did do that. She said, you know, that maybe Mrs. Wade and the lawyers, like Michael Roman's lawyer, Ashley, maybe they were all insurrectionists. I'm not joking. That was in her response. Says maybe they're trying to interfere with the prosecution of Trump, like hinting that, well, I don't even know what this is about. This is harassment. How dare you even question my office? That's how powerful these people are, how egomaniacal they become, how above the law they actually think they are. They're beyond reproach when they lecture all of us about no one being above the law. It's insane. But she did it, and now she's called out on it. Now, these grave conflicts of interest and this misconduct requires her total disqualification. None of this or none of these can be hand-waved by the DA. You can't just poo-poo these off. And all of her subordinates that are arguing that they are just about salacious sexual matters and office romances are irrelevant. None of that is true. That attempt to trivialize these issues should be rejected by this court in firm terms, saying in February, on the 2nd, the state responded to the Roman motion and the filings of Trump. And the state, Fani and her office, they said 5 things. They said that DA Willis has no disqualifying conflict of interest, no financial problems, and that there was no personal conflict of interest. They said any criticisms of Mr. Wade's qualifications were unfounded because he was a judge that time, and that DA Willis has not made any public statements, except that church speech, that warrant disqualification. And number 5, that the process by which Fani hired Wade doesn't justify a dismissal. No basis for dismissing him there. They said, well, we're going to take each one of these by turn and show you why they're wrong. Let's explain. Judge McAfee says the state and Fani, they acknowledge, they admit that there was a personal relationship between Willis and Wade. They said it began sometime in 2022. Sometime. That's a pretty broad spectrum there. Now, in this context, personal relationship is a euphemism for the intimate romantic relationship alleged in the Roman motion. We are saying that they are indicting each other, you know? Now, the state does not deny that the DA was receiving personal benefits in the form of lavish travel. Admit that. Not denying that personal benefit. Also, not denying denying that the amounts that that the amount was paid under contracts by Fani's office, or that the Board of Commissioners never approved the contracts. Okay, not denying any of that, just impliedly accepting it. Now, instead, the state confirms these facts, and not even implied, and they argue that they do not show any disqualifying conduct, and therefore they do not matter. They say, fine. Well, to rebut the existence of a financial conflict, they give us this evidence. Here's their evidence. Oh, there's no financial problem. It's not a money thing. Don't worry. Here's the state's evidence. They provide very vaguely and very scant evidentiary support. They say that DA Willis, Fani, and Wade's travel expenses were, quote, roughly divided equally between us. Oh no, there's no conflict here. Put that on no separate checks because we're honest people. Not that that would really disqualify anything, but it was even between. They say, okay, well, the only documentation, even if they make that allegation, the only documentation for Fani that she roughly equally divided travel expenses are travel receipts. They got us the receipts. They're Delta Airlines. There's the purchase of 2 tickets for $697 each. And it's on some identified credit card account. We don't even know whose account this is. So if we accept that this was paid for by Willis on some unknown credit card, this is the sum total of documentation that she's provided for her paying for travel. That's it. So $697 times 2 with Mr. Wade. And this is all that they could gather? Like, this is the entire bit of evidence? Like, you guys were flying around, you went to Napa Valley, you went on the Caribbean cruise, you went onto a Norwegian cruise. Like, these are nice things, man. So what else did you split? You gave us 2 airplane tickets on all your little lavish love affairs? All right. So that's all that the state could marshal. That's everything you could get. You have a team of literally 12 lawyers plus investigators and staff from the period from January 8th, when this original complaint was filed by Mr. Roman. He submitted it a month ago. And between February 2nd, you got 2 airplane tickets for $1,400? This figure is far less than the documented expenditures by Mr. Wade. For the benefit of Miss Willis, all right, he spent a lot more on her. Doesn't seem very even to us. And it does not even come close to showing that Mr. Wade and his claims that their travel expenses were roughly evenly divided between them. We've got evidence. We've got a bunch of other expenditures from the divorce proceedings, and we know that Nathan Wade was like cashing out, man. He's like, man, just, I got this contract, but, now I got to take her on all these cruises. He's like, Mr. Wade, he's in the middle of divorce litigation, and he was even held in willful contempt for his divorce case. He was concealing his income, which is a dishonest thing, right? A judge said, stop disobeying my orders. Willful contempt of concealing his income from his wife in the divorce proceeding. Now, here's an interesting footnote. They say this legal commentator, this guy called Harry Littman, he's a former U.S. attorney. He yesterday on YouTube that he learned that DA Willis also received outside legal help. Of course she did, because their office is full of dum-dums. He said that on that YouTube video, probably a good video. Fulton County DA bites back against Trump's weak attack. Maybe he's on the other side. He said the 176-page motion actually got an assist. Says, we don't know. I don't know exactly who it is, but there have been some outside lawyers who've been joining the cause, he says. Everything is so different. We're in a fishbowl. That includes people who want to be helpful if they can. In terms of overall lawyering in this case, this guy says, I also see, I think it's been solid though. I have from the start, wow, charging it as a RICO has a lot of implications. I care most about the speed. I think it's a big vehicle to try to lumber down the road and also be quick. Okay, so it sounds like this guy's a pro-prosecution guy saying Fani's bringing in some other people. Now they say this is wild. All right, so if that guy is saying Fani's bringing in other stuff, such outside assistance makes more remarkable the thin nature of her response to Roman and the motions on the issue of luxury travel. Yeah, he says evidently she is drawing for purposes of responding not only on her 12-lawyer team, but also on an unknown number of other outside lawyers scouring records and performing legal research. And this is still all they could come up with, is his point. It's like, wow, I wonder what kind of contract she's paying those outside lawyers, and is she sleeping with them? What's Nathan think about that? He's like, hey, baby, who are all these outsiders, man? You got a contract with him? I thought we only had contracts together. Now you have a contract with him too? I thought ours was special. So the court should require DA Willis to disclose who has provided that outside help, and maybe whether she's sleeping with them too. My words, I don't know. Whether they have taken any oath as a special assistant and how they might be compensated, so that it can be evaluated as a possible improper gift and other ethical standards that bind her. They wanted to write in there, and sleeping with them too, but they didn't write that in there. I'll add that for them. I know that's what they wanted to put in there. I know it, but I'll put it in there. So this is Jeffrey Clarke's motion. We'll help, we'll fill in the gaps for him that they can't put in court filings. We submit as well that the fact that Willis is receiving outside help underscores the political lawfare nature of this prosecution. Yeah, where's it coming from? George Conway's team? Particularly Littman's reference to the cause and the need for speed. What cause? It's a political cause. Why the need for speed? Well, because it's an election battle, obviously. So great, footnote there. Now we'll see what the judge does with that. But, I think he'll just say, okay, it's a lawyer, whoever he's talking about, I don't know. But it's an interesting footnote. Now, on January 8th, Jocelyn Wade, the victim of this this affair. Home wrecked. Remember, Nathan Wade got the contract with Fani one day. The very next day, bye Jocelyn, filed for divorce. Signed it with Fani. Woo! Feeling good over here. Oh, sad divorce over here. Bye, right? So then Miss Wade served a subpoena on Fani. She said, you got to show up to this divorce. Then Fani filed an emergency motion. She doesn't want to spend any, time testifying there. And then they settled that case because, I think Nathan was like, you can have everything. You can have whatever you want. Have the car, have the kids, have my future kid, whatever you want. I don't care because I cannot have you put my lover on the stand. So the main thrust of the motion for the protective order is that she's protected by the Apex Doctrine. She says that in her motion for a protective order, Fani Willis, the gall, accused Mrs. Wade of obstructing, which is a crime, obstructing and interfering with ongoing criminal prosecutions. Fani uses the power of her office to slam this back on Jocelyn. How dare you demand me coming to your divorce to testify? Well, I dare because you slept with my husband, apparently, at a 2019 judicial conference, and we're getting divorced now. And apparently he's hiding funds that you were paying him to the tune of $1 million that are marital assets that are part of the divorce. That's why. She turns around, and I'm telling you, right, these prosecutors in these offices have a ton of power. And this might work if this were not a national case, right? Like if she just sends this letter, this notice, oh, you're coming after me. How about I prosecute you for obstruction, right? Like that's a real threat. Now she made that threat in this filing, and these lawyers are not obviously going to take that. Obstruction and interfering by subpoenaing. This is you're doing, Fani. You're not above it just because you're biggest Fani and Fulton DA. The DA motion also asked for time within which that she could complete review. And she said the DA wanted to investigate and depose relevant witnesses with regard to the interference and the obstruction motion that this contends. So she's going to open up an investigation against Jocelyn. It's sick. In this filing, Fani crudely exploited the power of her office to threaten Nathan Wade's wife with a criminal investigation and then possibly prosecute her in order to gain personal advantage for herself and her boyfriend in her boyfriend's divorce. It is so unethical. She's going to not only not have to testify, but she'll just put his ex in jail. Don't even need a divorce. Well, just put her in prison. You don't have to pay her alimony, okay? She'll just go to prison. Love you, baby. So Mr. Wade's concealment on an amount of his income in the sworn affidavit also appears to violate Georgia ethical rules, right? Mr. Wade willfully was held in contempt. And these are the people who are prosecuting, 19 people, -4. The DA's emergency motion brought unfortunate results. Now, the very next day, Mrs. Wade filed a response because they called us, insurrectionists who were interfering with the prosecution. The very next day, Mrs. Wade filed a response. She said, oh, well, this is not obstruction. This is not interference. Why don't you look at the credit card accounts? Here's some actual proof of what we're alleging. There's documentary proof of the allegations. It turns out that Nathan did pay for travel. He went with Fani to Napa Valley, California. He went on cruise lines to the Caribbean resort destinations. Here's a copy of the response attached below. Now, before filing the state's response, then Miss Willis went out to the church. She stood there in front of her congregation to address the controversy. Now, while she did not deny the affair, in fact, she admitted to unspecified imperfections. I'm not perfect, God. She accused her accusers of racism, did it blatantly. Her statement was televised. It became national news. Video clips of her theatrically making the accusations of racism in the form of stentorian church rhetoric, punctuated by supportive murmurs from an amen corner in the church, were in heavy rotation on news sites and networks for several days. Why, God? And then you heard, right in the background. That's what he's talking about. Her waving the bloody shirt of racism. Wow. Fani's waving it in front of her congregation. Served no legitimate law enforcement, no public information purpose, and was intended to whip up invidious racial animus against the defendants. And it was done to deflect the attention from her own misconduct. You're racists. President Trump joined the Roman motion, move for dismissal. And then Fani and her letter to God was read at the Big Bethel Church. And her nakedly unethical threat to criminally investigate and prosecute Wade were grave breaches of her public and professional duties, carried out to serve her personal and romantic interest and those of her boyfriend in this divorce. Now, such grievous misconduct is intolerable in any lawyer, but especially a DA, and even more, especially in this case. Now, they are going to give us some analysis of the records of the finances. They say here, the following data that was taken from Fani's motion summarizes the personal benefits that we know and have flowed from Mr. Wade to Fani. Here are the records. Now, apparently, here's the summary of this. The 11/21 transaction date. There's a 1-year contract for professional services. They say apparently this is missing. Nobody can find this. Don't have the 1-year contract. Oops, where'd that go? Here on 3/1/2022, an execution of professional services agreement, which is another exhibit, from 11/21 to 10/31. And then we have some Royal Caribbean stuff. All right, so $2,500 here. 2 Royal Caribbean looks like, right, 2 tickets. That's a ticket, and that's like another maybe insurance. Maybe she can't go. Maybe she has to do some actual work. No, that's probably not true. So $477 a piece on 10/4. All right, here's more. $61, Freedom of the Sea, Miami, Florida, Hyatt Regency, Aruba, Norwegian Cruise Line. That's a big one, $3,000. You know, Norway, right? That's an expensive one. Execution of professional services agreement, Delta Air for Fani and Nathan, $800 a piece on those. Doubletree, Napa Valley, hanging out, sipping on some wine, and another, okay, $10,000. Now that summary, $10,000, is only what we know so far. And remember, Fani said, no, I paid the $1,400. Remember, she said that in my motion, and she submitted that ticket. She's like, 2 tickets here I paid for, so $1,400. No, and that is Fulton County money, baby. That's Trump prosecution money. That's pay for prosecution money. That money came, you know, if Nathan Wade said, well, sweetheart, this case is kind of insane because there's no evidence in any of it, so we can't prosecute it. She's got no cruise money. That $10,000 is gone. So the summary is based on what we know so far. And the total amount that is reasonably attributable, look at this number. Okay, the total amount reasonably attributable to Miss Willis's direct personal benefit on these statements is $5,000 before the indictment. Now, this amount is 7.8 times greater than the expenses paid by Willis, according to the documents that were attached. So 7.8 times more. Now, Miss Willis cannot be heard to claim that $5,000 are legally insignificant. No. In fact, the federal bribery statute, oh, love that, 18 U.S. Code 666, where applicable, is for $5,000 or more, the bribery statute. Now, prosecutions over amounts that are comparable are commonplace. $1,500 for a zoning bribe is enough. So $5,000 before the indictment that went over to Fani is enough for federal bribery statutes. And it's a lot more than whatever Fani paid. Okay, so in other words, she got $5,000 of benefits. They look through the same documents and it's like, okay, she got whatever that divided by 7.8 is, right? She paid that amount or whatever. It's a small number. Now, the state's response does not say a word about these expenditures. She got all those benefits, or there's 7.8x mismatch between the amounts that Fani paid and her sugar daddy paid. Instead, the state pretends that evidence does not exist and says that based on Wade's affidavit, they say to be absolutely clear, this is Fani, the personal relationship between Wade and Fani has never involved direct or indirect financial benefit. And there is no evidence, they say, that Willis derived any benefit from Mr. Wade. But from the evidence that we have right now, that claim is greatly exaggerated, if not flatly untrue. But the state is not content to merely ignore and mischaracterize this evidence. They also present her tribulations in this case as an ersatz ledger of offsetting sorrow by attaching as exhibits examples of profane and racist abuse. And remember, they did that. I almost went scrolling into some of those, and they weren't good, no doubt. And I don't condone or endorse any of that. And a lot of that is just very unwell people. And when you are, it's the law of big numbers, right? If you're going to be in front of 300 million Americans, it's just math, right? There's going to be somebody who's unwell, who's probably going to be on the email list sending you something. So I don't condone it if it's actual legitimate threats, right? They investigate that stuff. They even arrest those people and charge them aggressively, by the way, very aggressively. But what the heck does that have to do with these two sleeping with each other and paying him $1 million? What the heck does that have to do with anything? You guys are racist and I got bad emails. So therefore, I love Nathan Wade. Leave us alone. Here's another $1 million, sweetheart. Love you. The abuse is deplorable, they say. Obviously. Okay, no one condones this. Why are you bringing this up? And Mr. Clarke and his counsel join all moral observers in condemning it, obviously. But they just bring that out. They're like, you know, every time it's like their trump card. They just pull it out. I got attacked on email. Hey, Fani, why did you embezzle $1 million and go to Napa Valley? I got attacked in an email by a racist. All right, no, look, but can I ask you? No, look. All right, all right, I guess I'll leave. So, but with this argument, Fani is again, she's playing the race card to distract from her own professional misconduct. Now, it is also true that the DA has ridden state versus Trump a national glory. Fani is seeking national adulation information in congenial circles, including a hagiographic treatment of her role. Man, this motion has some $3 words in it. Of her role in the case by Michael Isikoff and David Cladman in their new book, Find Me the Votes, a hard-charging Georgia prosecutor, a rogue president, and the plot to steal an election. Oh man, I'm sure those guys are so mad they worked so hard on that stupid book. Could you imagine being one of those authors and just being like, okay, look, our book's almost ready. How's the cover look? Cover looks great. Looks great. Back from the editor. Okay, we made those changes. It's all great. Perfect. Hard-charging prosecutor. You can say that again, huh? I'm sure she is pretty hard-charging, if you know what I mean. So they go, oh gosh, our whole fake narrative that was going to be like this big book about Big Fanny's like, wow, what a queen and hero of America. And they're like, addendum, Fanny banged Nathan in a safe house on Fulton County dollars. Footnote 117. It's like, oh gosh, their life's work is ruined. So argument now, that's the background. So we'll see what's here. Prosecutors have special duties, right? They're not supposed to have any personal or financial interest in a criminal investigation at all. If you do, it conflicts with the Georgia rules of professional conduct. They swear oaths. The Supreme Court says they have high responsibilities. The Georgia rule of professional conduct says if you do anything that is going to materially or adversely affect the representation of a client, that's a problem. If there's any personal interest, you got to go. Now, if the DA is disqualified, if Fanny's gone, the entire office is gone. Here's the case law that supports that. She's gone. She's the top Fanny. She's gone. She's out. Now, if she is found to have personal or financial interests, the entire indictment must be dismissed. Whew, that's a good one. Now, the court has held in this prior case that a solicitor general's personal interest from a contingent fee, which is not what we're talking about, resulted in that one being dismissed. And here, there is no doubt that in this case, the grand jury issued the indictment long after the personal relationship and the personal benefits began. So they needed the indictment to come back, right? Otherwise, that's the end of the gravy train, man. If Trump's not indicted, they don't have cruise money. So even according to the vague reckoning of when their relationship began in 2022. And so thus, when the case was presented to the grand jury, Fani had a disqualifying both personal and financial interest in the prosecution because she gave her lucrative contracts to her boyfriend, and that contract funded their cruises. Nor did Mr. Clarke have any notice that he would be included in the indictment. Now, the state says that to be relevant to disqualification, that the personal interest must be in conviction, right? That there's an interest in the actual conviction. That's not the law. That's just them making this up. Their obligation is to do justice. It inheres in everything that they do. So the very beginning, like you've got an interest in the case going to trial to make more money. The conviction is not necessarily relevant. It's like the burden is on the defendant from being prosecuted. Now, the state concedes that a sufficient personal interest warrants a dismissal, but that no sufficient interest has been brought up here, saying the defense in this case did not learn about these benefits until January 8th. Otherwise, we would have brought it up earlier, right? But we just learned about it. Now, the interest has been shown, but the argument collapses, right? Fanny says, oh, there's no interest here. Like, what are you talking about? Credit card statements are right here. It shows substantial gifts to Willis before at least 2 of Wade's contracts were even executed. Credit card statements summarized above show substantial gifts to Willis before at least 2 of his contracts were executed and before the case was presented to the grand jury. Now, they say there's no prejudice. You know, even if we did all this indicting of each other, there's no prejudice. No one's harmed, right? There's no actual problem here. Like, so what if we're, you know, going on these little safe house retreats with our judicial robes? But it doesn't matter to Trump. They say no. Even it still matters, right? If you have a personal interest, you don't have to have a showing of prejudice, just that there's a conflict, even an appearance of a conflict. Now, they also say Fani violated her duties by making those comments at the church. They serve no legitimate law enforcement at all. They clearly violate Rule 3.8. The obvious purpose of her speech was to deflect from her own criticisms and to attack others. And it served her interest and Wade's interest. It was not being done in the public interest. She wasn't speaking as a prosecutor. She was covering up for her affair. Now, the speech is therefore a paradigmatic example of an actual conflict between their personal interest and their public responsibilities. She chose her personal interest before her professional responsibilities and went to church and lectured her congregation about how she's being victimized. So the state's response misses the point. It missed a lot. Their response was not very good. It first attacks the straw man that the speech is not constitute selective prosecution. Again, we said this when we read the reply, that they're arguing around the point. An argument that was not even made in Trump's motion, right? Didn't even make it. The next straw man that they slain was about a change of venue motion, which we didn't even file yet. Remember, she was like, Trump can't pick his own prosecutors. No defendants can. We say, okay, that's great. No one cares about that. That's not the argument. The argument is Fanny's got to go, not that we can go pick someone. Now, they're kind of close, but not the same at all. They sound close, but they're not. Now, the argument argument actually made by Trump, but studiously ignored, rests on policy interests. The rules say extrajudicial comments that might heighten public condemnation of the accused are problematic. So not only you speaking, but will it heighten the public's condemnation of you? Is it going to exacerbate the negativity towards a particular defendant? Guess what? Yeah, the murmurs through the crowd when she said, "God, why God?" and the alleged racism of her critics are direct proof of that very condemnation. The rules say no condemnation. Well, you heard it, that murmurs in the crowd saying, yep, and comment that this is literally designed to prevent. It is an unfortunate reality of modern American life that race runs through many public issues and controversies. But in light of this, prosecutors have a special duty not to whip up racial animus, not to whip up resentment against the defendants that they're prosecuting, especially in jurisdictions like Fulton. Now, the DA's, Fani's, her breach of the rules is so flagrant, it's so outrageous that it warrants a dismissal in this case. It warrants a disqualification of her all on its own. It's all the more egregious because she did it to distract the public from her own misconduct. Like, she's not speaking out like fired up on behalf of a victim or something, right? Like, this woman got, attacked. Okay, relax. You get passionate and fired up. She was defending her own bang sessions with Nathan. The entire case is now certainly irreparably tainted, and it is tainted, only worsening the taint of the financial conflicts of interest that existed before the indictment was even handed down. Now, she also violated her code by threatening to prosecute Jocelyn, totally innocent. A more naked threat of criminal prosecution is hard to imagine. Says that she put in a public filing, right, in writing, the bravado, brazen filing of interfering and obstructing with a criminal prosecution, right? She said, we need time to go investigate this. It is indisputable that this threat was made not to advance a legitimate law enforcement interest. She wasn't getting interfered with by Jocelyn, but it was to gain an advantage for herself. She was threatening Jocelyn with jail and her boyfriend in her boyfriend's divorce case. Oh, don't worry about it, honey. I'll just threaten her with investigations. It is one thing and a bad thing for a private attorney to violate this rule, but it's a whole nother thing for a Fani to do so, a DA. In this instance, Fani has again breached her professional responsibilities to the people of Fulton County, and it warrants disqualification. Now, she says our contracts were also totally appropriate, but that can't withstand scrutiny. Under the Fulton County Code, the rules say an interest is any financial interest, personal or not. Now, it's undisputed that she has caused substantial funds to be paid to Wade, regardless of any personal relationship she might had with him. Wade is a prohibited source of gifts. She caused him to get paid. She cannot accept something back, whether they're indicting each other or not. The gifts and favors section that she received from him show that there is an actual conflict. The law says it. Gifts and favors, anything of value given or received from a prohibited source. We read all this yesterday. Someone who is a prohibited source, somebody doing business with the county, or somebody over whom you have authority. Now, the state contends that Miss Willis has not received any gifts, but the evidence shows otherwise. And so it's clearly enough to show that there was lavished, expensive travel from Wade to Fani that we, of course, have documented. Now, they can't waive this conflict of interest, right? This is not something that anybody can just, write off. And she needed to go take this to the board of directors in order to get this approved. But the county's purchasing code, these are the procedures. This is how you have to award the contracts. Here are the things that Fani violated. Prohibiting employee conflicts while they're contracting. Requiring prompt disclosure of financial interest. Violated that. Violated that one. Prohibiting kickbacks or any other employees involved in procurement. You can't get, kickbacks. Violated that. All of this. She says we weren't required to comply with any of this. But the authority that she cites is bad. Any longtime resident of Atlanta will recall a long parade of local government officials and the contractors who bribed them being packed off to federal prisons. Whether the gifts given to Willis by Wade and the sole source no bid contracts, whether they're in the same category remains to be seen. Oh man. All right. So one more time. Any long-term residents of Atlanta, they'll recall long parade of local government officials and the contractors who bribed them going off in buses to prison. Now, whether the gifts that were given by Willis to Willis by Wade and whether the sole source of the no bid contracts by Fani to Wade are in the same category remains to be seen. You're going to jail. All right. So they say neither the DA nor Mr. Wade disclosed their conflicts. They were required to do that. There's forms, disclosure forms that we've already looked through, and they don't contain a disclosure. And so here, the affidavit also in his divorce did not disclose his compensation. He's been covering this up for a while. He said his income was $14,000 per month, but records from Fulton County say it was $30,000 per month. Why is Nathan Wade being so dishonest? Weird. I wonder if he's being dishonest in his prosecution of the president and 18 other people. Nor did Mr. Wade Wade disclosed the source of his compensation from Fulton County. Now, 3 days after the indictment in this case, he was held in willful contempt by the court in his divorce for hiding the income from his wife. Contracts with Mr. Wade by Fani were never submitted to the Board of Commissioners for approval. If she submitted them, they would have never been approved because there would have been conflicts of interest. She never disclosed her conflicts of interest, hiding the gifts that she was receiving from her contractor and her boyfriend. This is just great. And Miss Wade did not file his oath until defense counsel raised the issue, right? Covering the whole thing up. I don't know how these people thought they were going to get away with this. It's so brazen. The DA's office in the county have also, it's like they didn't even do anything. Like, you have to fill paperwork out. That's like half the job. And counsel from Judicial Watch, they got records. Shout out to Judicial Watch. And so now they're all filing lawsuits. The totality of the circumstances show that Fani was evading the contracting procedure. Multiple failures. They made multiple misrepresentations under oath. DA and Mr. Wade's dovetailed evasions and omissions benefited them both. It covered up their personal and financial relationship, and it didn't unveil their disqualifying conflicts of interest. This is like bad. And this is crafted like almost like an indictment. You know, it's like, my gosh. The cover-up lasted 2 years, during which the DA paid Mr. Wade over $653,000 and his two other former law partners $200,000. The longer the cover-up lasted, the longer the scheme could continue, the more Mr. Wade could be enriched, and the less his divorce would cost him. The enrichment by these methods inured to Fani's personal benefit. Through their relationship, they traveled together, and although the DA asserted the contrary based on the Wade affidavit that we read here, she has refrained from putting in her own affidavit. There is no Fani affidavit. There is no real, or at least there is scant evidence that they split the cost of the trips, the gifts, or the dates equally. And so in conclusion, Jeffrey Clarke's team says that the DA has Fani has repeatedly lost track of the distinction between public interest and self-interest. She has 3 stark conflicts, and courts must intervene. She's got a personal and financial interest in this. Lucrative and improperly awarded contracts that she benefited from. There is a kickback scheme in action here. And she also gave a speech. She tried to foment racial resentments to get out of her own scandalous predicament in violation of the rules. And third, she threatened Jocelyn Wade, the innocent party and victim of this home-wrecking scandal, with prosecution for daring to pursue her own divorce in a separate divorce proceeding, saying the administration of law, and especially that of criminal law, should be like Caesar's wife, be above suspicion, and should be free from all temptation, bias, or prejudice, so far as it is possible for our courts to accomplish it. But that's not happening here. Fani is afflicted by a veritable compendium of grave conflicts of interest that require disqualification of her and her entire office, and dismissal of the indictment, which has been tainted by her and Nathan Wade's participation in this entire scam from the inception. Signed by Harry McDougald and Catherine Bernard, 2 lawyers out of Georgia. Shout out to Catherine Bernard and Harry McDougald for putting together a very nice motion, almost like an indictment. Quite good. And you can see that Fani is not going to be too happy about having to deal with all of that, because every time we go through this, right, people are putting more pieces of the puzzle together. They're assembling this record. Everybody's digging now. All the defense attorneys are digging. And it's like chum in the water. You know, it's like, let's go get it. So we are very excited to see where this goes. Jeffrey Clarke now joining the other co-defendants in Georgia, and the hearing is going to be scheduled the day after Thanksgiving. So we're going to see if Nathan Wade and Fani Willis are hungover, emerging from their, safe house slumber or whatever it is they're doing, and see if they show up for the hearing and how Judge McAfee rules. So my friends, wherever it is you're watching us, thank you for subscribing. Thanks for liking this video. Thanks for checking out some of our links down in the description. I'd invite you to go and sign up for another Lodge event activity. We have an unboxing happening upcoming at the Lodge. So watchyourlodge.com. The events are free, but they're only posted live for a limited amount of time. So sign up for it. That way you don't miss it at watchyourlodge.com. If you want the PDFs, those are available at robertgovea.com, and you can sign up for the newsletter there as well. And we'll look forward to seeing you right back here on the next one.